Good evening to the participants of the AP+TS-JCJ-2023 for the screening test, which is going to be held respectively TS on 23rd April and AP 24th April 2023. And today is the second session of the Indian Evidence Act 1872 and the virtual class 18th, and tomorrow is a holiday that you can spend your time with your family and relatives. Now let us start with our talk virtual class, because the last class that I dealt the 19th question, and before the other people join, I put a diagram here, a photo, admissibility and relevancy. Now you can tell me which is the genus and which is the species. Anyone can unmute and give me the answer.
Admissibility is genus, relevance is species.
Appreciate. Admissibility is the genus and the relevancy is the species. So that is the thing which I want to make it clear from you. And now let us start our 20th question. Yes, the time is also now, yes, nearly 6:41, means 9:11 p.m. of India time. Okay, 20th question. Be ready to shoot. Latest judgment. I repeat. Latest judgment of the Supreme Court on 6 B Evidence Act. Bench consisting of dash also agreed with the view to take in Anwar versus Bashir case law, which held that Section 665 B is a complete code in itself for the admissibility of the electronic evidence and shall not be affected by the other provisions of the Evidence Act. Now, I did not ask the name of the case law. I did not ask the section because I already given here, but I would like to ask now, who are the bench consisting of? A. Chief Justice, Justice Rastogi, Rohinton Fali Nariman. B. Chief Justice Y. Chandrachud, Rohinton Fali Norman. C. Chief Justice Kurian Joseph, Rohinton Fali Norman. And the last D is Chief Justice Mohammed Khader Ibrahim, and the next is Rohinton Fali Nariman. Out of the ABCD, now shoot, who are the bench? Correct answer.
B. Answer B.
Option D, sir.
B for Bombay, D for Delhi, WRON.
Chief Justice of B.
Second option. B is wrong. Means B Bombay is wrong.
D.
B Delhi is wrong.
D.
Then you choose between the A and C.
C, sir.
C is the right answer. The Chief Justice Kurian Joseph, Rohinton Fali Nariman. Sometimes the questions may be asked because I saw it. Who are the judges and who delivered the judgment? So the same question, but I asked it in a different style. Now let us go to the 21st question. Recently, it has been held by the Apex Court that Section 27 is an exception to Section 24 to 26 of the Evidence Act, observed in the case of Dash. And here, that is a Sanjay Kishan Kaul MM Sundaresh is a JJ, the bench. Now, which is the case law? A. Mukesh versus State of NCT of Delhi. B. Himachal Pradesh Administration versus Om Prakash. C. Jafaruddin versus State of Kerala. D. State of AP versus Gangula S. Murthy.
Option A, sir. Mukesh versus State of
Option A is the right answer. Mukesh versus State of NCT of Delhi. Now, I would like to ask this, many times I asked, what is meant by NCT? I told you several times.
National Council for Transport.
T for territory. N. C for what? See, I told you several times, but again I will show you what is the full form of LCT.
Continent.
Read.
Host.
As I read.
National Capital Territory.
National Capital Territory of Delhi. NCT. So that is the thing which I would like to say to you. And next, Now the right answer is Mukesh versus State of NCT of Delhi is the right option for the 21st question. Next, be ready. 22nd question. Other settled legal propositions regarding the section 27. The following proposition of law are well settled in which of the case law? A. Praveen Kumar versus State of Karnataka. B. State of Himachal Pradesh versus Jeet Singh. C. Mukesh versus NCT of Delhi. D. None of the above. I think that...
Option A, sir.
Yeah, because that is the answer. Because to me, Praveen Kumar versus State of Karnataka. Okay, let me verify it, which is the right answer for that one. Because I want to ask something, but I missed some link there. That is the reason that I could not make it out. Other settled proposition regarding the section of the following proposition is there. That is the case law of section 27. But I want the case law. Yeah, it will come, don't worry. Yes, it has come. This case law is, Jafaruddin. Is it Jafaruddin case law? You see, merely many things are appearing here. Yeah, let us check whether Jafaruddin is there. No. Okay, let me clear it later. This case law regarding which one is the correct answer. Okay, now 23rd question. In dash, Arjun versus Kailash is also well-known case law, and this case law will supersede the other three case laws which is says about the 65B, and there is no confusion at all. Has now clarified the interpretation of the section 65 capital B. Confusion arose over the scope and ambit of the section 65 capital B as a inconsistent view had been taken in three earlier decisions of the Supreme Court. There are three earlier decisions. It is giving a different, but this case law make it very much clear. So what is the name of the case law? A. Arun Pandit Rao Kotkar versus Kailash Krishna Rao Gortial, and B is Anwar PK versus PK Bashir. C. Shafi Muhammad versus State of Himachal Pradesh, and D. Tommaso Bruno versus State of Uttar Pradesh. I already gave the answer.
Option B, sir. Anwar versus PK.
I already gave the answer in the question itself.
Yes, sir. Option A.
Option A is the case law. Please remember the case law. This Arjun Pandit Rao Kotkar versus Kailash Krishna Rao Gortial. In this case law, there is no confusion at all of the 65B, and there is no inconsistency would be there, because some inconsistency we found in the Anwar versus PV and PK Bashir, and Shafi Muhammad versus State of Himachal Pradesh, and Tommaso Bruno versus State of Uttar Pradesh. The three cases law also deals with the 65B, but the confusion is removed by the Supreme Court in the Arjun versus Kailash case law. So these are the earlier three cases. Now 24th question. Justice Nariman as well as the Justice V. Rama Subramaniam noted that apart from a few minor alterations, Section 65B was a reproduction of the UK Civil Evidence Act of 1968. Which section of the UK Civil Evidence Act of 1968? Option A, Section 4, Option B, Section 5. Option C, Section 6. Option D, Section 7.
Option C, sir.
WRONG. Second option.
B, Section 5.
Option A, sir.
Section 5, Bombay B is the right answer. Section 5 of the UK Civil Evidence Act, it is less modified minor than incorporated in the 65 capital B. Now 25th question. However, even if watched in a private area of the pornographic content showing dash would still be considered illegal. Number 1, child rape. Number 2, child pornography. Number 3, virtual private network VPN. Number 4, violence against the woman. These are the 4 statements are there. I said, what is that answer question? Pornographic content showing dash would still be considered illegal. So here the options which I have given is A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 4.
Option D, sir. 1 plus 2 plus 4.
Option A, 1 plus 2
WRONG.
plus.
No.
Option A, 1 plus 2 plus
D
3.
is the right answer. Child rape, definitely it is a considered illegal. Child pornography definitely is considered illegal. And violence against the woman definitely will be considered as illegal. Virtual private network VPN. Of course, it is a terminology regarding the compact system of the taking and showing the network by following the 2 models. That is the virtual private network. It is some countries it is illegal, in some countries it is illegal. Now let us go to the next question so that we could be known which country is VPN is illegal and which country VPN is legal. Virtual private network.
Sir, what is the answer, sir?
Here, virtual private network is illegal.
So 1, 2, 4 is right answer.
1, 2, 4 is right. I
D
told you. D is the right answer.
Okay.
26th question. VPNs are illegal in dash countries. Number 1, North Korea, Belarus. 2, India and Uganda. 3, Oman and Iraq. And 4, Turkmenistan. Options. A, 1 plus 2 plus 3. B, 2 plus 3 plus 4. C, 1 plus 3 plus 4. D, 1 plus 2 plus 4.
Option C, sir. 1, 3, 4.
I already gave the answer here. VPN is not illegal. When I say VPN is not illegal, automatically you can remove that thing. Then you can say 1 plus 2 plus 4 is the right answer. 1 plus 3 plus 4 is the right answer. India and Uganda, it is not illegal. VPN is legal. You can show. So now let us see the 27th question. Facts that may be proved as a part of the register must be facts other than those in issues must be corrected with it. Though hearsay evidence is not admissible when it is a register, it can be dashed in the court of law and may be reliable evidence, which is the appropriate word in the dash. A, admissible, A, inadmissible, B, admissible, C, irrelevant, D, relevant.
B, admissible.
B is admissible in the court of law and may be reliable evidence as per the facts that may be proved as a part of register must be facts other than those in issue must be corrected with, though hearsay evidence is not admissible, but when it is a register it can be admissible in the court of law and may be reliable evidence. So 28th question. Electronic documents are admissible as a material evidence. Yes, very clear. The computer-generated electronic records in the evidence are admissible at a trial if proved in the manner specified by dash of the Indian Evidence Act. Which section says? As per the specified way. Section 65, B, Section 65, capital A, C, Section 65, capital B, D, Section 65, capital C.
65
Option
capital B.
C, sir.
It is very easy answer because we are all revolving around the 65, capital B only. So answer is C. 29th question. Anyone can unmute and read? Read.
Union Minister Smriti Irani leaves the Fab India store in Goa on April 3rd, 2015. Goa police have filed a charge sheet against 4 employees of Fab India in connection with the dash filed against them after Union Minister Smriti Irani alleged that the store had a CCTV camera in the trial room. Option A, prurience case. Option B, pornography case. Option C, voyeurism case. Option D, trial room case.
Option C, sir, voyeurism case.
Voyeurism
It
case.
is a voyeurism case. Voyeurism means if any person is changing the dress or making the things, people will watch them to see the naked body. That is called voyeurism, or we can say Tom peeping also. Okay, next 30th question. Dash evidence as any matter of fact, the effect, tendency, or a design of which is to produce in the mind of persuasion, affirmative or disaffirmative of the existence of some other matter of fact, and quote. Who said? A. Wigmore
William
defined.
D.
B. Amir Ali defined. C. Bentham defined. D. Sir William Blackstone defined.
Bentham, sir.
Is the Bentham defined?
Bentham. C.
Yes, evidence as any matter of fact that affect the tendency of or design of which is to produce in the mind of the persuasion, affirmative or disaffirmative of the existence of the some other fact, I unquote. It is defined by the Bentham. 31st question. In the case of dash, the Supreme Court made the following observation on evidence. The word evidence has been used in common parlance in 3 different senses: as equivalent to the relevant, as equivalent to the proof, as equivalent to the material based on which courts conclude the existence or non-existence of the disputed facts. In which of the case law it is decided? Number 1, A. Vijendra versus NCT of Delhi. B. Emperor versus Aftab Muhammad Khan. C. Kalyan Kumar Gagoi versus Ashutosh Agnihotri and others. And D. Kishore Chand versus State of HP.
Option A, sir.
A for America.
Yes, sir.
WRONG.
Option C, sir.
Option C is the right answer. Kalyan Kumar Gagoi versus Ashutosh Agnihotri and others. In that case, law it is decided. Now, 32nd question. Which one is the following statement among the 4 statements is wrong? One is wrong. A. The term evidence refers to the state of being evident, that is plain, evident, or notorious. B. However, it is used to describe something that tends to produce the evidence or proof. We can define evidence as a process that deals with both the right and the duties. C. The Indian Evidence Act contains the number of provisions governing examination, relevancy, admissibility, and evidence of facts. D. Confessions, character relevance, the burden of proof in criminal trials, dying declaration, expert opinions, and various stages in the witness examination. Among the A, B, C, D, one is wrong. Which one is wrong?
Option D, sir.
WRONG.
Option B, sir.
Option
B.
B for
B
Bombay.
for Bombay.
Suppose if I say it is wrong, where is the wrong word is used there? Suppose I say this is a wrong, okay. Where is the wrong word is used? However, it is used to describe something to tend to produce evidence or proof. We can define evidence as a process that deals with both the rights and the duties. Where is the wrong?
Rights and liabilities.
Rights and liabilities. Last
Rights
duties
and
is
procedures. Rights and procedure. Is it clear? Say yes.
Yes, sir.
Yes.
Good. 33 question. Section 1115 to 117 of the dash deal with the issues of the estoppel. Another rule of leading evidence. These provisions prohibit a person from giving the false evidence by preventing them from making contradictory statement in the court of law. Which chapter it deals? A. Chapter 6.
8.
Let me finish first all the options. Be patient. A. Chapter 6. B. Chapter 7. C. Chapter 8. D. Chapter 9. When I say shoot, at the time you have to shoot. Yes, now already you shooted in the middle. So, chapter 8 is the right answer. 34th question. Which one of the mismatch among the following? I say mismatch. Let me draw it down. Please note the point. I say mismatch. Section 11 capital A establishes the presumption of dowry death. 2. Section 113 capital A provides for the presumption of the suicide abatement if a married woman commits a suicide within 7 years of her marriage and has been subject to abuse by her husband or his relatives. 3. Section 11 capital B establishes a presumption of the guilt for certain offences. 4. Section 114 capital A provides for the presumption of the lack of consent in some rape prosecutions. Options: A 1 plus 2, B 1 plus 3, C 1 plus 4, D 2 plus 4. Shoot.
B 1 plus 3, sir.
B 1 plus 3 is the mismatch. The reason is, see here I have given the feedback. The feedback clearly says,
13 dowry death.
yes, section 111 established the presumption of the guilt of certain offences. So I did not change anything, only I changed 1 and 3. This 1 and I 3 changed, the rest of the other things are as it is. Is it clear? Say yes.
Yes, sir.
Yes,
Good.
sir.
Good. 35th question. Nemo debit bis vexari pro una et edem causa. The equivalent is, which one is the exact translation or equivalent in the English language? A. States that no one can be punished twice for a similar offense. B. States that no one can be punished twice for an identical offense. C. States that no one can be punished twice for an equal offense. D. States that no one can be punished twice for the same offense.
Option D, sir. No one can be punished twice for the same offense.
Actually, I should not supposed to read. I will ask you to read. When I read it, no. Srinivas, say mute.
okay.
When I read it, no, you know the rhythm. When you know the rhythm of it, your eye will not catch the other things. Your eye will catch, no, sorry, your ear will not catch the other things. Your ear will catch those things, those you heard it. So you never saw for a similar offense, twice for an identical offense, twice for an equal offense, twice for the same offense, because your ear already feeded with this same offense, hence you can easily make it out. So 36th question. Interest republicacit finis litium. These are the two maxims the entire law of evidence is based on. If they ask you in the examination, what are the two major maxims where the law of evidence is based on, at that instance you have to give the two answers. Because I will give the fourth question also. Ubi just ibi revdium, and the next one, actus reus mensitria, or I can give you actio personalis maritem ca persona. The personal action of a man dies with the person. If the four maxims are given, the two are right and two are wrong. Okay, now what is the exact meaning equality here is, which is the right answer? A says that it is in the best interest of the state to put an end to litigation. It is based on the public policy and ensure that the lawsuits don't go on for too extended. B says that It is in the best interest of the state to put an end to the litigation. It is based on the public policy and ensure that lawsuits don't go on for the too long. C. Says that it is in the best interest of the state to put an end to the litigation. It is based on the public policy and ensure that the lawsuits don't go for the too elongated. D. Says that it is the best interest of the state to put an end to litigation. It is based on the public policy and ensure that the lawsuits don't go further too stretched. This is a bit.
Option A, sir.
This is a bit. I don't know whether you can make it out or not. If you
Option
say
A,
the
sir.
option A, WRONG. If you say the option A, it's a WRONG. Next option.
B.
B is the right answer. Because you hear it me says that it is in the interest of the state to put an end to the litigation. It is based on the public policy and ensure that the lawsuit don't go for too long, not too not too extended and not too elongated, not too stretched, because that our ear will not catch it in a proper manner. If you have heard this maxim or seen this maxim or read this maxim, you can easily make it out that the C is the right answer. That is, go on for that is B for the right answer, too long. That is, don't go for too long. Is it clear? Say yes.
Yes, sir.
Okay.
Yes, sir.
Please, anyone can unmute and read. 37th
The
question.
second portion of the Act. The second portion of the Act is titled The Relevancy of Facts. This section contains 51 sections, starting from section 5 to section dash. Can you please?
Yeah, it is there.
Option
You
A
can see.
53, option B 54, option C 55, option D 56. Answer is option C 55, sir. C 55.
55 is the right answer. C is the right answer. The relevancy of the fact. The section of the 51 sections are there total. So it starts from 5 to 55. So 38th question, mismatch the following. I say mismatch, not the point. The relevancy of facts are the part of the same transaction. Section 6 says. 2. The facts of the constitute the occasion, cause and effect of the facts in issue. Section 7. 3. Facts showing the motive, preparation and conduct, previous and subsequent section 8. 4. Facts required to establish the fact in issue, etc. Section 9. Which one is the mismatch? A. 1 plus 2. B. 2 plus 3. C. 1 plus 4. D. 2 plus 4.
One plus 4, sir.
WRONG. Second option.
Sir,
It
D,
is the
2 plus
answer
4.
B. 2 plus 3.
2 plus 3.
Yes. Feedback you can see here. I did not change anything, only 2 plus 3 I changed it. If you happen to see here 1, 2, 3, 4, you can easily notice that. Yes?
They are not. Options are right, sir. Section 7 deals about motive, preparation, and conduct.
Facts showing the motives, preparation, and conduct, previous and subsequent is section 7. And what I wrote here?
No, sir. 8, sir. 8.
I changed it, no. See, I changed the 2 and 3. Is it the right, I made it here? Did not change it. This should be here and this should be here. Or I made the confusion. No, I changed it here.
You made reverse, sir.
Yeah, I made reverse, I think. Yes, I
Answer
made reverse.
Yes, sir.
So what is the right answer then?
All are right.
See, if I made the reverse also doesn't matter. Wrong is wrong, is it not? Is it or not? Is it or
You
not?
gave in feedback.
Yes, sir. Yes.
See, the other two I did not change it. Am I right? Am I right?
I mean, what I mean to say is all four options are right only.
Achha, our four options are right only, that you want to say. Okay.
Yes.
Now, if I want to make it wrong, I should make like this now. Now you tell me.
Yes, sir. You should change. Yes, sir.
Now you tell me.
So option 2 mismatch. So option B is the right answer.
See, I changed only 2, 3. Now it is
Yes,
right.
sir. No. Yes, sir. It's right.
No, when I say 8, 7, when I say 8, 7, here I should say 7, 8. See, when I change that thing or this thing, doesn't make any difference because I did not change the number 1, number 4. Are you following me? Might be right. I wrote the right there. But now I wrote the wrong.
Now it's okay, fine.
No, suppose let it presume it. Let us presume it. Something I wrote wrong. Of course, the right when I shown, then wrong I cannot say. I have to show there wrong and the right I have to show in the feedback. Okay, now I believe it is right in the feedback and wrong here. Am I right?
Yes, yes.
Please check it. Please check it, then you tell me. My point is,
Yes,
even the questions can be asked in this style also. So that is the I want to keep in your brain. Okay, 39th question. In the case of Dash, the Honorable Supreme Court has clearly ruled that when the prosecution relies on the subsequent statement recorded after the accused was detained, such a material cannot be considered sufficient material on record even for arresting a person. And which case law is decided? A. Kishore Chand versus State of HP. B. Emperor versus Aftab Muhammad Khan. C. Adam Bhai Suleiman Bhai Ajmeri versus State of Gujarat. D. S.K. Yusuf versus State of West Bengal. Shoot. In which case that is decided? Speak. Even though it is wrong.
Option D, sir.
Means D for Delhi.
Yes, sir.
WRONG.
Option
A,
C, sir.
Kishore Chen.
Kishore Chand versus State of HP. WRONG. The right answer is C. Adam Bhai, Suleiman Bhai, Ajmeri versus State of Gujarat. 40th question. In the case of Dash of the Supreme Court held that a person would not die with the lie on his lips because he had to meet the supreme power of this world, that is God. The court further observed that the sense of imminent death produces the man's mind in the same feeling as that of a righteous man under the oath. Therefore, the chances of the falsehood are totally nullified. In which case light is decided? A. Maksudan versus State of Uttar Pradesh. B. Ukaram versus State of Rajasthan. C. Kushal Rao versus State of Bombay. D. Pakala Narayana Swami versus Emperor.
D. Pakala Narayana Swami versus Emperor.
Wrong. No doubt it is a dying declaration. There are 5 cases are there in the dying declaration. And 5 are discussed here. If anyone asks any question in the 5, I am sure that you can easily shoot it out. The facts here is a man who is going to die on his tip of tongue, truth is there. That is dealt in the case of Ukaram versus State of Rajasthan. Now let us read the 41st question. In the case dash of the accused cut throat of the deceased girl, due to which she could not speak, therefore she indicated her finger towards the person who cut her throat. The Allahabad High Court held that no particular form of recording of the statement is prescribed. Therefore, a dying declaration can either be in the form of an oral statement, written, gestures, others, if any. Any dying declaration made through the signs and nods is also relevant. I already told this case law yesterday. A. Maksudan versus State of Uttar Pradesh. B. Ukaram versus State of Rajasthan. C. Kushal Rao versus State of Bombay. D. Queen Empress versus Abdullah.
Option
D, sir.
B.
Empress versus Abdullah.
I said in my last class R versus Abdullah. In some cases I found R versus Abdullah, but some cases I found Queen Empress versus Abdullah. But anyway, either you say Queen, or you say Regina, or you say Rex, or you say King, it is a state. Is it clear?
Yes, sir.
See, in the throat is slit for the girl and she could not able to speak. Then she has raised her finger and shown the person who cut her throat, slit her throat, larynx. So even gestures, nods also come under the dying declaration. Not necessarily it should be in a oral form. Either make it oral form or a written form or a gestures form or a nod form or body movement or demeanor. It will show it is amount to the dying declaration. Okay, next. A box containing the dead body was found in the third coach of the train. After a few days, the wife recognized the dead body of her husband, who is no more. During the trial, the wife told her the court that her deceased husband had to told her several times that the letter obtaining the amount of the loan. Also, when she last met her husband, he informed his wife that he was going to collect the money and he was threatening not to give back the borrowed money. The court held that the statement made by the deceased to his wife when he was going to collect the money from someone was admissible as a dying declaration under Section 32, Class 1 of the Indian Evidence Act. Now you can tell me the Andhra case law. What is that
Option
case
D,
law?
sir. Pakala Narayana Swami.
Pakala Narayana Swami versus Emperor. Because the husband said that I am going to collect the money which he borrowed it several times he told. And before going also he told the same thing. But after going there, after 2 or 3 days that he found his body would be there in the box in the coach. That is the Pakala Narayana Swami. A dying declaration is treated as a substantial considerable piece of evidence. Means it is a considerable piece of evidence is given in the Kushal Rao versus State of Bombay. It is also dying declaration. A dying declaration is treated as a substantial considerable piece of evidence. It's a Kushal Rao versus State of Bombay. And in this case, the court held that the declaration of the statement survives. Then the statement cannot be used as a dying declaration under Section 32(1) of the Indian Evidence Act. However, it can be used for the purpose of the corroboration under the Section 157 of the Indian Evidence Act. Contradiction to the Section 124 of the Evidence Act, that is Maksudan versus State of Uttar Pradesh. In Maksudan versus State of Uttar Pradesh, what happened? He did not die. Is it clear? In the Maksudan verses, he did not die. But, however, it can be used for the purpose of the corroboration. The dying declaration can be used as a corroboration under Section 157 of the Evidence Act and for contradicting under Section 145 of the Evidence Act. So some contradiction comes over there. At that instance, we can use it also, even though that fellow is not died. That is given in the Maksudan versus State of Uttar Pradesh. Now, in the dying declaration, any type of the question will be asked, you can easily make it out. Is it clear?
Yes,
Say
sir,
yes.
yes.
Yes. Now, 113A. I already give the answer. Okay. Now, presumption as to abatement of suicide by the married woman. When the question is whether the commission of the suicide by a woman had been abetted by her husband or any relative of her husband, and it is shown that she had committed a suicide within a period of 7 years from the date of her marriage, and her husband or such a relative of her husband had subjected her to cruelty. When you say the cruelty, same meaning of the cruelty should be taken in the IPC. What is the cruelty in the IPC?
498A.
Capital A, not small a. 498 capital A. The court may presume, having regard to all the circumstances of the case, that the suicide have been abetted by her husband or by such a relative of her husband, or which section of the Indian Evidence Act says. I already gave the answer.
Option B.
Option B is the right answer. That is 113 capital A. So in the 44th question, of course I will read it because you cannot read so fast. In dash, it was upheld that there is a presumption of death at the end of the 7 years, although there is no presumption as to the actual time of the death. The specific time, the death is not a matter of inference, and the burden of proof lies with the individual seeking the right to prove that the death occurred at a particular time. Now, 4 options. A. Jayalakshmi Ammal versus R. Gopala Pathar. B. J.T. Commissioner of the Gift Tax versus Sri Shervans J. Shah. C. SMT Radha Gajapati Raju versus the Assistant Controller of the Estate Duty. D. Ponduri Adaya versus Jaladi Burraya.
Option D, sir.
WRONG. The right answer is Srimati Radha Gajapati Raju versus the Assistant Controller of the Estate Duty. That is the right answer. Is it clear? Now next question, 45th question. In the case of dash, it was deduced that if after 7 years of the absence, the presumption of death applies, the person shall be assumed to have died by the end of that time. Where the presumption does not apply or is substituted by proof, it shall be determined on the facts of the case in question. A. Lalchand Marwari versus Ramrup Gir. B. C. Mohanta versus M/O Railways. C. Life Corporation of India versus Permanent Lok Adalat and other. D. LIC of India versus Anuradha.
Option D, sir. LIC of India versus Anuradha.
You are right. It's the LIC of India versus Anuradha. That is the right answer. So today I made roughly many questions, very long manner. But still we do have how much time? 9:52 India time and 7:22 local time. So 9:52, 9:10, still 5 to 7 minutes are there. Okay, now what I want to say is, law of evidence. Law of evidence, Indian Evidence Act, Bear Act. Evidence Act, Bear Act, So Evidence Act, Bear Act, again, if you want to see it, see, we are disputing about the section 7 and 8, no? At the time. We are disputing about the section 7 and 8, See, 5, evidence may be given of the facts in issue and relevant facts. 6, relevancy of the fact forming the part of the same transaction. 7, facts which are the occasion, cause or effect of the facts in issue. 8, motive, preparation and previous or subsequent conduct. These 2, which I changed it. Is it or not?
Yes.
In our 6, 7, where you make it out? How do you find it? Can you find it by this way? Motive. Yes, we found it. Oh, it is gone. It is here. This fact showing the motive, preparation and conduct, previous and subsequent section. Motive is there 7. Now what we wrote here, Motive is there in 7.
8
See,
should be in
motive is
8.
there, preparation and previous subsequent 8. That means what I wrote in the beginning is the right. I made it change. Of course, now I made it change. Motive should come 7 and it's 8. So now it is right. Not beginning is right. Beginning I wrote from 7, 8. Is it not?
Yes, sir. Yes.
Now here 7, 8. Okay, motive comes here. Now it's no problem at all. And another, we made the which we made the confusion, no, in this one was the case law. Oh, this is 19 we are going. We have to go to the 21. Admissible, not admissible. Yes, this is a species, a genus. And is this case law that we discussed about it? Yes, recently it has been held by the Apex Court that Section 27 is an exception to the Section 22, 24 to 26 evidence as observed in the case of Dash. I think why I it? Because these are judges. And this is the case law. Jafaruddin versus State of Kerala is the case law. The right answer is Jafaruddin versus State of Kerala is the right case law. Is it clear? This case law only confusion or another case law is confusion? I think this is the confusion case law.
Confusion.
This is the confusion
Another
case law.
question. No, sir. Another question related to Section 27 was asked. That down question.
Yeah, that's why I say this is the
question.
relevant case law. This is the. I think to me, let me check it. Mukesh versus this case law goes in that manner. Of course, this case law we already discussed, no? Mukesh, one of the case law that is seen.
Option 22 option should be
Let me check it. Let me check it. Among such events took place in India, a remarkable incident was the case of Mukesh and the city of Delhi, that the popularly known as Nirbhaya case. The Indian rape laws don't allow use the victim's name in the media. No, this is a different one. No, this is the different one. So this is the case law. Let me check with the Jit Singh case law, State of Himachal Pradesh. Yeah, the session found that the murderer, consequently Jit Singh, the respondent was convicted. Uxoricide was sentenced to imprisonment. No, this is also not the relevant. No, let us see the next. Only this is left now. Because we are dealing with the Section 27. Land principal Session Judge, Dakshina Kannada, Mangalore Nihar judgment, Session Judge, so and so thing. This is a different one. 302 it is. Anyway, that I think I don't know what I have forgotten there to make it out. When I was preparing it, something I forgotten, or that a case law will not mention here. Other settled legal provisions regarding the Section 20.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।